I'll take it out to the YouTube.
Yeah, perfect. Thank you, Matt.
Thank
So,
you. Take care.
Thank you, Francis. It's nice to see you again.
Yes, same here. Same here.
Now, basically, what happens is,
Can you hear me okay?
yeah, it can be a little louder. It can always be a little louder.
Oh,
Now, basically, what happens is,
can you hear me okay?
yeah, it can be a little louder. It can always be a little louder. I think, okay, well, what's happened is, Francis, the YouTube is also playing there. You'll have to just shut the YouTube window. YouTube is also playing. YouTube is also playing. You'll have to just open the YouTube window. YouTube is also playing.
Okay, so I need to switch that off.
Yeah, you'll have to just switch that off.
You have to just open the YouTube window. Okay, I need to switch that off.
Yeah, you'll have to just switch that off. Basically, you just have to go to Chrome, and there'll be a window there where the YouTube is playing. You just have to close that window. Basically, you just have to go to Chrome, and there'll be a window there where the YouTube is playing. You just have to close that window. Isn't it?
No.
Yeah.
Better.
Yeah. Better. I think it's good. So, Francis, what we are doing here is this is symposium number 8, mediation legislation, the how, what, when, where, which, who, or why of that. And of course, Francis will tell us about himself. And Francis, now we have 50+ speakers from 30+ countries.
Okay.
And hopefully we get more people. I mean, I'm okay. I don't mind extending the symposium. I think topic is important. We should get people from all countries. So let's open that. So Francis, it's about you. Please tell us about yourself and the topic. And you have time. There's no session after yours, so you can take your time. So
Okay.
please.
All right. But I think maybe I should just start by saying, yes, I am a judge. Actually, I'm a Court of Appeal judge, and but my interest in mediation goes back to prior to my becoming a member of the judiciary. Having actually did a master's degree in conflict resolution at Nova Southeastern University in Fort Lauderdale, Florida, and of course that also meant that I was trained in mediation. There was a very significant module in mediation in that master's degree. And after that, I actually got involved in helping to train other people to be mediators. Did a few mediation sessions myself before becoming a judge. After becoming a judge, then I became what you would call a mediation administrator. So I was in at the administrative end of mediation in a number of different islands of the Eastern Caribbean, starting in, marginally in the British Virgin Islands, and then more integrally in Grenada, where I became the chairman of the Court Annexed or Court Connected Mediation Committee. I moved from there to St. Kitts, did the same thing in St. Kitts, Court Connection Mediation Committee chairman, and from there to St. Lucia, which was my last posting before I came back to Barbados, which is where I'm from. So in Barbados, I don't carry that position, but of course, the position of influence is still there. And I've been speaking to the individuals involved in the administration of mediation here about different things that they can do to improve the circumstances. We actually went through a situation in COVID in the midst of the most serious lockdowns, where we were looking at having a practice direction for online mediation. And I think there are some mediation sessions that are being done online at the moment as well. So that was, one of the developments that came out of those discussions and that work that was done at the time. So that is a very brief introduction. I've had an opportunity to speak to lawyers, law students in India on Zoom. in the Commonwealth Law Association that would have been in Belfast last year in May. And prior to that, I had gone to Europe to a session on mediation in Madrid, Spain. And thereafter, I became a Weinstein Fellow, senior, and I'm now a senior fellow of the Weinstein Foundation, which is a foundation dedicated to training mediators out of the United States, but it has trained mediators all over the world, some of whom work with the United Nations and other international bodies. So I myself work half-time, they call it, for the United Nations, but as a judge and not as a mediator. So that is the background. But
Francis, if I ask you to come a little closer to the mic, is that possible?
yeah, sure. Yeah, because
that's a little low, the volume there, and we want to.
I was looking to see how to increase the volume, but I never remember how to do these things.
I think just have to be closer. So that's why I wear headphones, because here the situation is every.
You have the mic right at your mouth.
So now it's all about mediation legislation. Please.
Right. So I've listened to a couple of the other sessions, and I think that I can understand the amount of information that is already out there about mediation legislation. I just want to approach the topic from three angles. One is the intention behind passing such legislation, and just speak a little bit to that, what I perceive to be the intention or the intent. Next is the context, which is of course connected to intention. And finally, how do we give it meaning? Those are the three headings that I wanted to look at. When one looks at and I would say that I had an opportunity to actually be involved in not the first draft, but looking at the draft as it kind of evolved in St. Lucia. I think there were two drafts. One had to do with mediating in commercial matters, and the other had to do with mediation, community mediation. Both of them had similar clauses, etc., and similar flaws, similar benefits. So I think there's always an extent to which the persons who draft this legislation or the institutions or interests want to control mediation in a sense. They want to be able to say also, of course, that they were the persons who initiated it, and they are the persons from whom the benefits flow. So they want to take the benefit, and they're saying, well, they now have the burden of also assessing how this thing should be administered. So that's where I think a lot of it comes from. I do recall some time back speaking to an individual who is responsible for the funding of some programs in law administration in the region, that's the Caribbean region. And her thing was, well, you know, when we get legislation, we can impose standards. And so I can understand that. There is a consideration and a concern about standards and the need for standards so that people don't go out there and kind of, pose, that's how we would put it in this part of the world, as mediators, but in truthfully, in fact, they have little or no skills, and they just want to cash in on something, a new trend, let's say. So we can understand, I think, the need for the regulation, and therefore the, putting up or imposition to some extent of some standards. And of course, there's going to be some discussion about how far that should go. I mean, there has been this, I think I saw in one previous discussion on this sessions, where it was being argued that clearly one does not need to have a degree, or a law does not need to have a law degree. And I totally agree with that, because in the first area, the first country where I worked as a mediation administrator, one of the best mediators that we had was an engineer. He never studied law. He was an engineer. And in St. Lucia, one of the best known and most acclaimed and requested mediators was a former public servant, a retired public servant. He wasn't a lawyer. So these things are true, that you do not have to be a lawyer or a person with a law degree, or even a person with any degree for that matter, to be a good mediator. I do recall in the British Virgin Islands being involved in the training, and I think that we used to put a criterion there in relation to some standard of education. I don't think it went as high as to say that one had to have a degree. And then we would train you as long as you had a certain standard of education. And thereafter, you know, it would be determined whether you performed well enough in that training to be put on the list, which was the list of accredited mediators for the purposes of the court. And I think that kind of accreditation is attached to legislation all over. Of course, when we talk about legislation, we're talking about it at two tier levels. There will be the national legislation. In Barbados right now, we don't have such legislation, but in St. Lucia, that draft I looked at, I think that one has been passed. So they would have national legislation. And then you have court rules and practice directions that are connected to the court practice, which form a kind of legislation as well that the lawyers are familiar with and those who come before the court. So there are two tiers of that legislation, which determine issues relating to how mediators work, the limitations, what they must do, what they, and so on and so forth. So the practice direction then would go into detail about how a mediator would operate if they're doing court-connected mediation. A system that's set up to deal with community mediation would do, one would think, the same in relation to community mediation, but it may be a bit more relaxed in the sense that in those circumstances, although things like confidentiality would still have to be there, you might not have to worry too much about things like whether or not the information would be used in court, et cetera, because it would not necessarily be connected to a court case. So those are some of the considerations. There's an extent to which there may be some persons who see it as an opportunity to find a new area of work, so that the legislating of it and the fact that they can go and get a certification will give them an opportunity to open a new office, figuratively or literally, online or otherwise, and that would be a new area of income. And of course, from the point of view of the state, a new area of revenue collection, because if they're going to have to register every year, you're going to have people pay a fee to register. And that was so certainly for the court-connected mediation. They registered with the court and they paid the court an annual fee to be on the roster. So we look at all of these things and we realize that there's certain intentions, there's certain benefits, there's certain burdens coming from mediation legislation. And of course, as you go through it, one has to notice certain things popping up. In the Caribbean, where I had encountered it, one of the things that I had to advise on a lot was try not to overlap too much with what the court-connected mediation is already saying. Try not to, and indeed, do not contradict, if possible, do not contradict what the court-connected mediation is saying. Try not to be too legalistic in the sense of you draft legislation and then you put a lot of information in there, a lot of directions in there about filing applications and, and affidavits attached, et cetera, et cetera. That is a little too formalistic for a community mediation kind of legislation, guiding legislation, where you want to determine how mediation can be initiated. It shouldn't have to be on the basis of a person filing an application and that kind of thing. They should maybe come in and fill out a form and say what the situation is about, and then the mediator is selected. So we could look at those kind of things. So that in a nutshell is how I look at the issue of intention coming onto the legislation. The legislation has those kind of characteristics. The intentions are those that I set out. Now, when it comes to context, it is difficult to get away from mediation being connected to law in some respects. It is difficult because a lot of conflict out there in the society has some kind of legal connotation at the end of the day. Up to last night and during the day yesterday, I was talking to a friend who for some time had directed the disaster preparedness or mitigation program in the Caribbean, in most of the Caribbean. And it's interesting how in that particular area where I had previously written a short article about using mediators, I come to realize more and more that out of a disaster arises a whole lot of legal issues, and even pre-disaster, and of course post-disaster, and during any situation, arise a whole lot of legal issues. Some of them, one would hope people will sit down and discuss and work out in a mediation kind of context. Others, individuals will have to be reminded of people's legal rights. And this is where then the whole question of a negotiation in relation to those rights arises, which can then become a mediation session. But the issue of a right in existence, I think, is what kind of pushes certain persons or interests towards the negotiation table. Let me put it that way, whether it be the negotiation table of a one-on-one or a mediation situation where a third party is assisting with the negotiations. So it is difficult to get away from lawyers having some kind of interest, and a lot of interest in it. And interestingly enough, you do have a breed of lawyers, I think more and more, who are coming into the marketplace, who are not really intent on taking everything to court. They're using their legal skills, but they are using their legal skills to, as I just articulated it, remind people that people have rights. They remind and direct, and they advise people on the rights that they have. And they put that up then as well. Are you going to speak to these rights, or are you going to do something else? And if you're going to speak to these rights, it's better that we sit down around a table and have a discussion, have a negotiation or a mediation session where a third party can come in and assist. So there's this section. Some of them call themselves collaborative lawyers. Others are just lawyers who do nothing other than mediate. And not everything has to be a matter that went to court. But I think many conflicts have the potential to end up before court. And that is something that is very difficult to get away from. It may be that in the pre-mediation situation, one is able to lead individuals away from that option if, of course, that is desirable. But at the end of the day, I think it may not necessarily be a negative thing that individuals are reminded, you know, this is a conversation here about legal rights, and it may very well end up before a court, and a court will have to make the decision. Whereas you have your opportunity here to determine the outcome. And this is so even in interpersonal matters. In my experience, that I learned a lot while I was in St. Lucia as a high court judge, with the interpersonal matters arising from divorce cases, where the highest rate of resolution of mediations was in the divorce mediation area. So that what it appeared to me is that culturally, for whatever reason, in that particular country, people wanted to get their situations dealt with expeditiously, wrap them up, and move on. And the interesting thing about it was that the rules or the practice direction, which directs people towards mediation in the court situation, did not include family law. But yet these people opted to go to mediation and use the mediators on the court roster to determine the outcomes in their matters. So I think it is very important to understand that even in those interpersonal kind of things where values and emotions and so on playing sometimes a much greater role than any legal connotations or consequences, there is still, of course, the possibility of a legally determined outcome. And that is where the lawyers come in. But you have that in some cultures, I would think, I guess it might differ from culture to culture, that strong tendency to want to get certain kinds of interpersonal matters over and done with. And when I compare it to what I see coming out of the United States, where I went to an online training, I attended an online training sponsored by one of the online platforms in family mediation. And I mean, I learned a lot from that. And of course, in a developed society, you have a whole lot of services that may not be present in a developing country. And therefore, you have services for people who want to get advice on researching other individuals' economic stance and so on and so forth. There's not as much of that in our situation. And some people may argue, well, that means that some people probably don't get a fair deal because they really haven't done the research. They're really not able to actually look behind all the smokes and mirrors and so on to see what's really going on and for a proper settlement. But be that as it may, the thing is that, you know, people will still tend to not want this situation to be hanging over their head for too long. And therefore, they go to mediation, and it is one of the highest success rates. I think they had a 90-something% success rate in the interpersonal issues related to divorce. And when I say interpersonal issues, I'm also talking about material issues, which are connected to those interpersonal issues. We have to do division of property, children, custody, etc., etc. A lot of these things were settled fairly quickly and efficiently through mediation. So I think those things are very important in terms of the context, because it means that shadow of a court situation is very often somewhere lurking in the background, even if not in the forefront. Somewhere in the background, it's there lurking, and it can pop up in relation to insurance or skill sets and efficiency of persons who are doing certain jobs, or all sorts of things can cause this particular context to arise. As I was saying earlier, even in the context of a disaster, where what is driving the mediation, or what is driving the legal issue, is extreme discomfort, sometimes death. Persons dislocated from their property. They don't have a home. They don't have food to eat, or they're looking to see where the next meal will come from, etc., etc. In those circumstances, you again are looking at the possibility of legal issues lurking somewhere in the background. But having said all of that, I just wanted to read a little something here, which in a draft article that I had done, I had referred to, and I had referred to the writing of one William Lucy in 2002, where he referred to something called the skeptical challenge, and concluded that the question that the challenge places on the jurisprudential agenda is this: are law and adjudication preeminently desirable means of subjecting human conduct to the governance of rules and resolving disputes about those rules? So, this is the profound question, really, because I think if you come out of law school, you assume that, well, there's nothing else like a legal procedure to solve a problem, And then, but then if you allow yourself with an open mind to face reality, you realize that that is not necessarily so at all. The matter may arise from a case that is filed in court, but it is very unsuited to being resolved in a courthouse, because the presence of persons with adversarial, almost the interest is to be adversarial, and the presence of adjudicator who wants to hear the adversarial contest and make a decision that is his or her decision. These are issues, these are aspects of the context that drive that process, but they may not be suited to a fair or just resolution, or a resolution which both parties can feel comfortable with at the end of the day. May not be suited to that at all. And sometimes I think a story is often told of in one of the islands in the region where an old gentleman had put a younger person in court over something that happened in the neighborhood. And the case started, and he gave his evidence, and he ended by saying, well, all I want is an apology. That's all I really want, an apology. And the other side came up and they apologized, and he turned and walked out of the court. He didn't want anything more to do with the court after he got his apology. That was it. And the adjudicator who I spoke to, he said he understood entirely. He didn't call him back and say, well, you're being rude to the court or whatever by walking out. He understood entirely. This is all this gentleman wanted. He wanted to hear the other side apologize. As long as that was done, that was over. He could go on to something else. So I think that in terms of context, I'm saying that the legislation and the rules that deal with those contexts, and it's just one other thing that I want to refer to. Those things are very important. In the practice direction that we have in Barbados, which is almost identical to what we have in the Eastern Caribbean Supreme Court, one of the things that a judge has to consider a number of things before he or she refers matter to mediation. And I think this is also part of the context, but it also helps to understand the meaning, which is the third thing that I'm going to speak about, that we can give to mediation and mediation outcomes. So the first thing that the criteria for referral of cases speaks to is, in considering whether to refer a case to mediation, the judge, master, or registrar, as the case may be, upon the application of the claimant, shall take into account all the relevant circumstances, including A, the relationship between the parties. Okay, so the relationship between the parties, it can happen, as I said, in a commercial matter, in a neighborhood dispute. It can happen, of course, in a divorce case or other case involving a personal relationship. So the relationship between the parties. B, the willingness of the parties to resolve the dispute by a collaborative process. So if these parties, pursuant to the same court rules, had had a previous opportunity to speak to their willingness to resolve the dispute, or in their conversations with the lawyers, if the lawyers so allow it to be disclosed, that they are amenable to resolving the dispute by collaborative process, that is something the judge can take into account in referring the matter to mediation. C, the desire of the parties to seek a flexible process that will enable creative solutions. It's very similar to the one before. If in looking at their situation, they don't want to be rigid. They want to look at a way out, so to speak, but that where each one can walk away happily from the matter. The unwillingness of the parties to risk the unpredictable outcome of a trial, and add to that the comparative cost of litigation versus mediation. So that is basically skepticism about the court and the judicial process. And, you know, I think there's a lot of that, to be frank. There's a lot of that. And, but how strong is it in a particular case? How strongly do they feel about the unpredictability of the outcome of an adjudicated matter? Do they feel strongly that they have the judge listening to what they're saying on their side, or they have doubts? And then what could be the outcome? And then, of course, is the cost, and how that relates to mediation. Now, I should say here that among the practice direction and the rules, between the practice direction and the rules, normally a matter would be referred to mediation to be resolved within 45 days, I think it is. If it is not resolved in 45 days in a 3-hour session or 3-hour session extended, they can come back to the court to extend that deadline. So I go on then. Opportunities for joint gains not available through litigation in the court. Okay, so that sometimes there are things that have nothing to do with the law that persons can look at, and as part of basically something to consider, even if not openly discussed in a negotiation or mediation, it's something that needs to be considered. Friendship, maybe in the background, or a mutual friend, or something that could be of benefit to a mutual colleague, and they can be looking at those things as part of the need to a benefit of avoiding litigation. And then any other criteria considered appropriate by the judge, master, or registrar. So those things are very important at the time of making the decision. That's interesting too, because one of the things that came up in one of the legislation, in the legislation that I vetted, was that there was a clause saying that mediation must be voluntary. And while, of course, that is something that is desirable, in the court system, we can't really call it voluntary, because what happens is the judge directs the parties to go to mediation. So we can't really call it voluntary. So the argument there, or the tension there, would be, well, do we ask them to amend this desirable language, or do we accept the reality that there is always, well, shouldn't say always, but there's at this particular moment for sure, there's a context in which persons will be sent to mediation not on the basis of it being voluntary, not that they're resisting it, but they're ordered to go to mediation, and therefore it's not really voluntary. So we can look at those things and talk about those things. So what does this mean at the end of the day? At the end of the day, it means that there are many disputes that do not need to go to adjudication, where things can be nipped in the bud, and the areas of possible dispute are, broad and wide. As I said, I recently have been looking at the interesting, although unfortunate, area of disasters, and looking at the amount of issues that can arise pre, during, and post disaster, based on legal rights, expectations of governance, proper governance, etc., etc. These things arise and can be mediated, or of course, the law can be used in a court to coerce a particular outcome. Mediation, no doubt, is needed everywhere and in multiple contexts. And I think I have touched on a number of them. It's just for people's eyes to be opened to those contexts. And of course, one has to constantly be repeating the benefits. I think a lot of the times, the benefit that is not often enough spoken about is cohesion in the community. It's, if you take a conflict to its so-called natural course, or its legalistic course, or its arbitrary course, you will probably end up with a very negative social conclusion, outcome, and discomfort, long-lasting feuds in the society, etc., and the community. Whereas if persons learn how to resolve their disputes and learn even more from a particular process, then that is a benefit to the community at large. So to the extent that the legislation obviously is drafted with this in mind, and hopefully is true to its origin and cause, and does not do too much to interfere with the process and obstruct those deeply willing to be involved in this process, and therefore keep certain persons who would be beneficial to the process out of the process. I think that the community can look forward to benefiting a whole lot from the legislation. As I say, you constantly, however, have to look out for the red flags where they may arise. So with those words, as I would want to say, that is how I would want to contribute to the discussion. And I'd be happy to elaborate on anything.
Thank you very much, Francis. Of course, with your wide experience, you've brought us into a lot of spaces. But important thing what we need to do is look at it from the grassroots activity, that we want to develop mediation at the grassroots. And of course, there is that colonial judiciary structure that you are part of. So you've seen that. And looking at the issues on both sides, what would from your end, what would that legislation contain? You want to get into some specifics there? What would the
all right, I could tell you what I had to just wanted to see if I had it available to me up front, but I can tell you what happened. the individuals who draft this thing are probably lawyers themselves, and they usually are lawyers. They're what we call parliamentary counsel, or sometimes just a lawyer who is, contracted to draft the mediation. And first of all, they would try to define, what a mediation is. So it's very important that that definition be one that is acceptable to mediators. So it is important that mediators be part of this process of putting together legislation and and defining certain terms. If the legislation is intended to actually go into the process of talking about things like confidentiality must be guaranteed, etc., etc., and that is one of the things that can be included. My view is that is something that you want to put into a kind of a sub rule rather than into the major legislation. But if persons see the legislation having to interact from time to time with court proceedings or other kinds of proceedings like that, they may want to put that in there so that individuals do not conclude that they have the right to immediately take anything that they learn in a mediation and carry it to court, let's say. They would want to look at the issue of mediation training because, as I said, there will always be individuals who would want to be mediators, and there will be concerns about the abilities, the skills that those persons have to conduct a mediation. They would want, therefore, to be a certification process or a training process or a recertification process after having met the original standards. They would want to be a certification process, a continuing certification process. And therefore, an individual can go through that process and be included. And then, of course, you have to give them a right to appeal if they're not included by that process. There may be, as I said, a revenue collection aspect of it. And then there would be the question of what do you do with the outcome of the mediation? What do you do with the agreements, etc.? Are they intended to be legal documents, just documents between the parties, etc., etc.? So along the way, there are opportunities for persons to include things like what is the process for starting a mediation? How many attempts does a mediator have before you throw in towel and say, well, you can't do it, or things like that? Whether you want to go into that kind of detail or you really want to leave that to a sub rule that deals with the actual legal process, which is part of the mediator's training in any event. So those are the main areas that I can think of, and that I have read and that I have had to comment on in the mediation legislation. As I said, I don't think that national legislation has to also necessarily go into detail about things that are dealt with in court rules or what we call practice directions. So I do not know if that answers the question. As I said, a very brief.
But I mean, the answer was basically from Francis the judge. Now I want to take Francis to a village. Let's look at let's go. I mean, look, to think, we'll have to think from, see, I don't know how rural and what is the rural population in Barbados, but I'm sure there might be some rural areas. Let's just go into some village somewhere and let's look at it from that perspective. What is it that you would want as legislation for them, so that first of all, resolution, of course, takes place, but also the inconveniences and costs involved with the colonial structure, lawyers and courts. Of course, we definitely don't want them to get there at all. And
Right.
of course, we want to create a culture there, which of course might have existed at some point of time, which is where that discussion that I had on mediation in our culture and traditions and indigenous peoples and mediation, all those discussions I had to check, first of all, was there some kind of a system like that, or was it not there? I mean, it doesn't have to be there. It could have always been a kind of an arbitration, maybe some communities, we don't know. But for a moment, let me be optimistic and say there was there was a culture somewhere, and we want to strengthen, at least tap into it and then strengthen it. So let's look at it from that perspective. What would legislation look like in that kind of scenario?
Right. So the 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 reality there is that the legislation probably would not go too deeply into the historical position in terms of trying to see how it can really develop on that. But there's some consciousness of it, because I think what you would want to be able to be conscious of is the need to have it available for persons within their community setting, so that even in the small islands, you still find that some people don't want to travel certain distances. So, a guy got to travel 30 miles. He's not particularly happy that he has to travel 30 miles to get to an office that deals with mediation. So the mediation office, the institutional setting for it would have to be divided among major communities. What I've seen is major community centers or towns that are the kind of the urban centers for these major community centers. And they could be in a, as I call it, a community center, or they could be connected to the court in the sense that you have that idea of the multi-door courthouse. So that if you want to do it from the point of view of the multi-door courthouse, you tell people, well, when you go to the courthouse, you're gonna have a choice. You can go and file something to take a matter before a magistrate or a judge, or you can go and speak to some people who will tell you about the option of mediation or negotiation, and they will tell you then what are the steps needed to get that going. And then we would need, of course, to be able to talk to the person on the other side. So I think that that's what the long-term goal would be. I do not know that in terms of the actual drafting of the legislation, in the ones that I have seen, they have really taken that into account. But that is how I think I would like to advise, that they do that, because if the assumption is that people will still have to, at the end of the day, come to the major urban center, the city, uh, and that in itself is a cost. You have to pay a bus fare, and so on and so forth. That is going to be in itself an issue. I remember being connected to one association of farmers, and they were interested in getting a mediation system going, but eventually they gave it up. But that is a context that I would have thought would have been viable under the community mediation model, that an association could use its own facilities to have a mediation program going in that particular village, that particular community, and and help persons in that community sort their problems out. And in St. Lucia, where I worked for a while, there used to be a lot of issues in the farming community, where there'd be land encroachment, people taking each other's crops, animals, husbandry versus crop, etc., etc. So there are enough sources of conflict to keep a mediation center busy. So I would think that, and if one has to go, I remember speaking at a church in a rural community, although it was one of the larger towns in that rural setting, and two persons who were retired police officers came to me at the end, and they had two reasons for coming to me. One was they were from my country, and and they wanted to say hello. But the second part of it is that they wanted to tell me about how things were once upon a time, and as even as police officers, they found themselves doing that kind of work, where they could go into a community or a village and settle disputes. Uh, because they're close by. The police station is close by, or they're given a bicycle and they ride, and then they have to walk the rest, but they get it done. And but communities were a little less complicated in those days, and they have become more complicated with less people employed in the village. The village is where they sleep, but they get in a car and they drive 20 miles away to work. And that's where they spend the whole day. So you don't have the ease of, well, I go into the community and I can talk to everybody in the community in 24 hours. A lot of people are not working in the community. They're working elsewhere and they have to come back. So all of these things have to be taken into consideration when you're looking at how to set up your facility and determine what is best to have persons feel that the facility is part of their community setting and available to them on a day-to-day basis.
Well, I think, Francis, what we really need to discuss, and which is something which is, I feel, the root of the issue, is that there is a feeling on one end that everything needs training, everything needs certifications, and then you can get into it. I look at it from this perspective. We're looking at legislation. Are legislators required to be trained, certified to become legislators in Barbados? I don't know. I know in India, definitely not. In most countries, they're not. How come that becomes an exception? That's allowed. But everything else, we should look at how we can get in. And then, of course, that is one part, that, of course, legislators themselves are not certified and trained and everything. And maybe they should be or not. We can have a debate on that itself. But now let's look at mediation itself and that mediator mindset. Have we reached that stage when we actually know what all goes in there to train? Can it be trained, first of all? I mean, that by itself is a discussion that we have to make. Can you train someone to get that mediator mindset? Is it attainable? Because I'm looking at it from the other side, which we were talking to Matt. If it's possible, then in that case, you can train a machine to do it. And maybe a machine will do a better job, because maybe you can put in so much content there, the way things are happening in artificial intelligence. So is that how we are going to be looking at it, that there is this content, we can put it into you and now you'll become a mediator? Or is there much more happening there, as I've spoken about, and I'm sure we've somewhere had this discussion on the energy and heart, soul, spirituality, and all those larger things? Is that something which we've understood now, when we know what really happens there, that connection that is made? If Francis is who he is and what he brings, that mediator mindset that he brings, are we disregarding the individual now? Are we going to always have this thing that individuals don't matter? There are some systems. Can everything have systems, first of all? I've been saying, I mean, I'll give you some, I mean, I put out everything to you, then you can take it all together. One is, of course, legislators on one end. That's a different thing. Then on the other end is, are you then going to be in some way training and certifying mothers? Have you understood on a very box kind of thing, this is what a mother has to do, this is how they have to do it, and now we can train you to be, only then can you be a mother? Are we a fascist society? Are we wanting to create that we know exactly how two people will deal with each other, or what that dynamics is? I don't know. I mean, those are thoughts that we have to also put together, because when legislation happens, has this thought got into it? Or is it everything can be a system, everything can be certified, everything can be trained? So yes, Francis.
Yeah, I think that I understand what your concerns are. There is certification, I think, because I think behind all of these things, there is this feeling among some mediators themselves that they want to stand out, that they want to make mediation a profession, just like law, just like medicine, accounting, or whatever. And therefore, if there are standards for which persons can be trained, then it helps them to come to that level where they are seen as a profession. So I understand that tendency. There is also, of course, the fact that individuals who have a good understanding of human behavior, not necessarily from any theoretical learning, but from simply life, and they have that propensity to listen to people and to, you know, get out of them what you want to get out of them in a conversation and give back what you want to give. Those kind of individuals are also possibly very good mediators. But so I think a mediation trainer would have to be alert to those realities and realize that obviously it is not about academics, it is about innate abilities. And sometimes a person with the innate abilities will not necessarily shine as an academic, but they have the ability to resolve conflict. So I still see the need for some kind of training. I still see the need for leadership in the sense of a leader in the area of mediation should be able to recognize both types. The one that is good at it because they are good at regurgitating and you know, learning practices from a book, so to speak, and the one that learns it from everyday life and can practice it, it comes naturally. The leader should be able to see those things and understand those things, you know. But it's kind of difficult to get perfection in that area, and therefore I think we're going to have that tension for a while, until maybe we have different categories of mediators, you know, doing different things. But well, for a while, if you're talking about a country of the size of one of the islands in the Caribbean, the likelihood is that they would only have one set of legislation and one set of rules. So those rules would be dictated by that mindset, that there is a set of people who are in a better position to use the word dictate to the rest of the society what is best for them. And I think that is the extent to which the legislation, that's how the legislation is actually brought about. Because I think a set of people are chosen, or they choose themselves, and they say, well, we are better trained to let everybody else know what is best for them, and this is what. We have to have, hopefully, within that context, some leaders who can say, hold on. Listen, we got to soften that a bit and recognize that, you know, it's not all about the exams that you pass, et cetera, et cetera. There are certain skills that people will have because of their natural orientation, and those persons should be recognized in this situation as well and certified.
Which is what I'm saying, that the legislators themselves have kept themselves away from that, because maybe they feel this is something which is a human behavior. We understand the connection we make with people, so we should not be regulated. We are not to be certified, but we believe that we know what actually goes into human behavior and transactions and everything, and we can put it down into a system, and we can actually say, this is the training required, and we will gauge you. I'm telling you, basically, Francis, what it's coming down to is, again, another colonization. There is a class distinction which is being created in this certification category, and the actual person who is working or actually doing mediations on the ground, who actually, I mean, is the one that user is getting an experience from, and these certified ones where actually there's no work happening, because you have to see, there is I mean, the UK, there was a CETA report audit that has come out, and they say was, I think, some 200 something people who mediators have work, and actually there's some 18,000 certified mediators in the UK. 200 or something have work. There's no work happening. You've created a class, and obviously, you know, of course, they are going to get disillusioned. That's a separate thing. So there's fundamentally something wrong, and you continue doing that, thinking things will change. I mean, that's really, I feel, I don't want to use words for it, forget it. I don't want to say, but the point is that there is something more which is happening here, which needs to be looked at. And Barbados, for me, is the best example, which I spoke to earlier. Let's make that the experiment. On one hand, let this happen. Look, legislation you can control. Otherwise, a lot of people can't. Maybe you can give your suggestions and they'll be taken. But for a moment, whatever's happening there, whatever their thought process, there'll be institutions coming in from other parts of the world, and they will say, this is the certification that people need, and they'll basically, that's the money making racket which is happening. So let's let that happen. Let's, if we can control it, damn good. Let's go down to the grassroots level, and people that they identify, people will identify those people. These are the people with the mediator mindset. Let's take them along and at least, I mean, make sure that whoever people trust to resolve the dispute, legislation should not come in the way. They say, look, X is someone we trust. Let's go to the X, and no one should be able to stop them. But anyway, though, no one can stop anyone. Whom I get into my living room to help me talk to someone, is the government going to get into my living room to tell me whom you guys sit with? That's like colonization to an extreme. We're not being able to get over this aspect. These are two people getting a third person whom they trust. You cannot get into this. Was a colonizer's concept that you should not sit together. Come to me, because if you sit together, you'll resolve where am I going to come in. So I have to get my person into the picture. That's the mindset we have to change. We're still being dragged into that because it benefits the next lot of people who came in, who are the neo colonizers in every country. They are the ones who take over. They are not to be regulated, and they are going to sit and regulate, and that's going to come in every aspect. But I'm only, of course, limited to the discussion on mediation. And so I am saying that legislation cannot come into the play, and if it does come into play, needs to be challenged, that we trust someone, we want to sit with this person, and that person can help us resolve something. Legislation cannot and should not come into the way there. So that part we can, yeah.
I think that we're gonna, part of the discussion has to provide for persons to engage in that conversation at the highest level, and this is where I think, unfortunately, compromises have to be made in order to get there, in order to get a seat at the table. And because at the end of the day, who is going to listen to you? That's one of the questions that we asked and answered. We are in my own context in the Caribbean, we are struggling with our education system, because you're right. The education system teaches us that there's a certain class of people that are supposed to run things. And they will always be the ones who will run things. And they are the doctors and the lawyers, et cetera, et cetera. And nobody else is supposed to be running anything. And of course, we have to deal with that, because where has that left us? That has left us with large unemployment, and a lot of persons who are unemployable according to the employers, which is a hard concept for me to accept, but that is what I hear. So I think that we have to have enough of these kinds of discussions, these kinds of exchanges, where we produce leaders who can go out there and talk to other leaders about these things. And maybe as I said, I think there would have to be some compromises, but we at least might be able to say, well, okay, listen, we allow the legislation, but you have to relax the certification aspect of it and recognize that if a particular community says person A is an individual in this community who resolves conflict in this community, and we trust her or him to do that, there's, that person should be so certified. There should not be any exam or anything to get in the way of that individual being certified. So I understand what you're saying from there, but you've got to understand that when people are drafting legislation, as I said, there's a whole lot of lawyers involved, persons who want to be able to believe that they are entitled to call the shots and will forever be entitled to call the shots, and therefore they're right. And
Because I think it's a finding, yeah. Because the way, look, Francis, what will happen is, like you said, There will be lawyers who will sit and decide what that legislation is to be how it's going to be looked at, and that comes from a certain mindset. Let that keep happening. We can't fight a lot of systems because there is a lot at play there, but we can at least create that culture, like you said, that people know in a certain community that this person is someone who has that mindset. Let that legislation definitely even, I mean, no way can come into the picture when someone goes to someone and says that please help us, because we definitely want people to actually value these people in those communities, because what is happening is those people were sidelined because you created a structure of dispute resolution where you needed to bypass all this. Because like I said, if you are in your community are able to resolve things, then how do you create that divide? You need to keep that divide going. That's the colonizer's mindset, which is what has been picked up by future governments, I mean,
Right.
politicians. So that's going to be there. We'll have to, I mean, look, that politics and all will happen, but that's where the World Mediation Circle and mediation circles, which I spoke to you about, was this. Let that politics, advocacy, activism continue there, because we can't fight. There's a vested interest there. There's huge money on the other end. So that's going to keep happening. But when we go out and we identify these people with that mindset and create that atmosphere around them, and whoever has that mindset to amicably resolve things, collaborate, have good conversations, by itself that community will grow. And once that community grows to an extent when actually you value these people and an ecosystems developed around that, it will then have a force which can actually maybe look at legislation and change legislation also. Maybe, I mean, let's see as it goes. But we have to resist the colonization of mediation, because class distinction is going to be a big issue. Because next, what you're doing is that this person, like you said, in a community who's respected, this person is a mediator in that community. But you are saying person is not certified, is the is a class down there. These are the people who are mediators. Community benefits from this person, people are benefiting from this person, that doesn't matter. No, this is the person that we certify, and which is where it comes from the colonizers concept, which I keep saying. Savages, you are savages, you don't know whom to go to, we will tell you whom to sit with. We're just bringing that into something which actually has no connection with any kind of legislation. It is a people's process. But I'm saying that you want to get legislation in, there are certain basics that you want to give people the benefit of. It's a people's process. Confidentiality you want to protect, without prejudice you want to protect, mediator not being brought in as a witness you want to protect. Do all that, and at the end of the day you want to give that settlement agreement a force of a court decree. Give it. Perfect. That strengthens the whole concept. But nothing, anything beyond that, where you have interference in the process or the person whom they choose, then you are going against the concept of mediation and you are going to destroy it. And I think that's where it has to be stopped as much as we can. But I'm saying, even if it cannot be stopped, that ecosystem can be created at the grassroots level. No one can come in between that. No one can in this, I mean, any country, if they stop me from bringing someone in to sit with, I'm saying that's a dictatorship, a fascist kind of a situation. You can't stop two people to sit with third person. If it's possible in your country, either you're a police state or you become a judicial state or whatever word you want to use, a fascist, whatever. You can't stop two people from getting a third person in. I just cannot do it. And if you, I mean, that'll be go against the concept. If you call it yourself a democracy, then you've gone against the basic concepts of democracy, I think. So I think that can be still, that ecosystem can be developed. And on the other end, this class distinction that is being created, when you see the benefit in communities with these people, it'll be easy to show that this is actually a class distinction that you're creating, which is actually going to destroy this whole institution or this.
You see, this is I think what happens too is that the okay, so you have individuals who are able to do this kind of thing, but at the same time, you have persons inside of their own community whose context will be changing, whose situations will be changing. And this is one of the things actually that drew me to the fellowship that I did. Because what I was saying is there's a big connection between what gets to court and what happens in the community. And two things that give rise to a lot of cases that go to court have to do with family conflict and land conflict. And the family conflict has to do with persons having more than one family, like one gentleman having children from different marriages or different relationships. And that gives rise to a certain type of conflict. And then there is land ownership giving rise to a certain type of conflict. So there are those connections. So people need to be aware of that and recognize that as it becomes more complicated, let's say, you may need a different kind of mediator. Not that the one that is initially very competent at the community level isn't helpful at another level, but as it becomes more complicated, you may need a different kind of mediator. The other thing I wanted to say was there are a number of mediation systems that emerged, evolved from natural processes or within a particular context. Maybe I shouldn't call them natural processes, but they're processes that happened as a result of the interaction, let's say, of different types of different persons with different interests. And from my reading, it was, for example, in the United States, the immigration gave rise to some mediation processes because, of course, persons had to fight for their rights as new immigrants. And in that struggle, they had to find a way of talking to the other side. And eventually a mediation system arose there. A mediation system exists. It's called conciliation most of the time, but it's basically the same thing in industrial relations. And I have had to point that out in recent times in relation to employment legislation, where I say, well, look, you know, there seems to be this big rush to get the matter before court, get the matter before court for a judge to sort out. And I'm saying, well, you know, did they really complete the negotiation process? Did they really complete the mediation or conciliation process before they referred the matter? How am I to be satisfied that they did so before they referred the matter to an adjudication process? And these are things that I think need to be strengthened as well. In other words, the ability of the institution itself to question how well it is working, and in terms of what we would call that monitoring and evaluation. You question your own systems and how well they're working based on outcomes, et cetera, and complications. And you recognize somewhere along the way, but you know, this thing isn't really working the way we thought it should. Maybe we need to do some more training in the conciliators, some more training in the mediators. And the other thing that I wanted to mention was you can start out with one intention and then change totally. And that is what happened in Brooklyn, in New York, and it could happen elsewhere, where a mediation center was set up in Crown Heights. And that mediation center was set up because there were clashes between West Indian communities and Jewish communities after the West Indian Carnival Parade, or what is really the Labor Day Parade on the 1st of September, or the Monday closest to the 1st of September, which is called Labor Day in the United States. And they set up a mediation center to deal with those clashes, those cultural-based clashes. And then eventually what they realized was that the real need in that community was to deal with interpersonal violence, the violence between members of the community. So it became something, it metamorphized, changed into something very different, in which individuals were now being trained to simply go to persons and say, listen, we realized that there was somebody in your family suffered violence. We want you to think of the retaliation that you may be considering, reconsider it, and see what's the best way to try to resolve this issue, or if there's a better way to resolve this issue. So sometimes what you have is a mediation process in a community evolving from a conflict that springs out of the very basis on which that community has been formed. And in post-colonial communities, you're right, we have our own circumstances as distinct from, when I say post-colonial, so communities that only existed to our knowledge. Of course, there were communities in this part of the world that we have kind of unfortunately sidelined, and in some cases made them disappear. But by and large, new communities have evolved that were based on immigration and the differences between one set of immigrants and another set of immigrants. And in the case of my ancestors, slaves and immigrants. So that is the context in which any mediation system would have evolved. And of course, it never did, because, as you said, it was always the top-down structure that prevented it from really evolving. So those are the things I would want to add in terms of how you look at the evolution of mediation systems in various communities, and how mediators and persons who have mediation, as at heart in terms of their interests, would want to see how they can align the trajectory of mediation with what is actually happening in the community. We need to have some discussions in the communities about how they perceive their problems and how these things can be addressed in mediation. And not assume that simply because we open a mediation office that people are going to bring, a multiplicity of issues to the mediation office.
The thing is, Francis, for me, I've this whole structure that's being created around mediation centers and that kind of thing. I think in any case, it's creating a structure around something which it's actually not required. This is again people identify whom they want, wherever they want to sit out in a park or under a tree or in that person's living room or in their garden. It's just let it be flexible. The moment you're trying to create a structures because you think structures need to be created everywhere. And I don't think it's worked. I mean, if you look at it's a nice concept, it's funded by the state and all that happens, but it doesn't work out because it's a culture that you have to develop, and cultures don't develop by creating buildings or structures in that sense. Cultures develop in people's mind and how they connect with it. The other thing that you were saying is in terms of people always say that, okay, in the community you identify people, but they're the kind of work that they can do is limited to what's in that community. But what about more complex things? That's why we need more certified and trained people. I'm saying that mindset is what is required, and that person evolves. That's why that series that I had, Evolution of a Mediator, person evolves not by reading theory. It's person evolves by their life experiences, circumstances, and those kinds of things that evolve. And then your relationship in terms of with people, dealing with people, understanding people keeps increasing. That's your evolution taking place. People think that if we connect people with theory and that's what's evolving, no, they will connect. Those people with that mindset will connect with that theory. They'll really enjoy it. When Francis reads something on conflict resolution, a nice book, he enjoys it because he connects with it. But that hasn't helped him evolve. It's him being able to connect to theory which he already has in practice and believes and lives it. So, okay, it's nice. You read it and you connect with it. But that's not what that evolution has to happen. So these people whom we are saying that have the mindset in communities can handle the most complex situations, most complex matters. I don't have any doubt of that. If they're brought in, but again, this class distinction being created, oh, these are community mediators. They are not mediators. Mediators are the ones which are created by us. That class distinction will continue. They'll become, okay, you can do your work in the community. No, we have to get over that concept. These people, finally, like I said, the people who legislate and say that these are community mediators and the ones we certify are really mediators, themselves don't have any qualification. Those legislators don't need any qualification. They don't need, they themselves are, that's the colonizers concept. We can make anyone anything. We don't need to do that because finally we have to control, and if we have to control, we have to decide. I mean, we can't create any distinction. We can't say this qualification or whatever. We want the person. we will bring out whoever we want. So I feel that that part of it has to be brought down, that look, this is not that this is a community mediator. The person is a mediator, has the mediator mindset, can get involved in any kind of dispute. That is where the whole process has to be discussed, which we were discussing I was discussing with Matt in the last session also, that the aspect of the process and grasping what's happening there is the person's capability, and that's what the mindset is all about. Bringing in experts is the easiest thing to do. You have your lawyer who knows the law, bring the person in where that person is required. Bring in a civil engineer or an architect or any other person whom you need, who needs, you think that expertise is required, bring them in. But to say that that person has to do mediation, who has that expertise, I think we don't understand the process. And then what we are doing is we are entrenching people more into those rights based concept, because we are getting the expert who knows. Why do we need the expert? This is not a court of law that you have to give arguments against each other. So I think that whole process maybe is not understood, and the person's, what that person's that role in that whole process, I think that's also not understood. And people are legislating based on dispute resolution and the colonial structure of dispute resolution. I think that mindset is still there. So a lot has to change on that, and that's for me, that's grassroots thing I keep talking about. Because when you see that benefit and you see these people and they then bring in, take in, they get in more matters to do, they can brought in more mediations, they will evolve, and you will see that evolution will take place, and then they will actually be able to create that atmosphere around them, the culture around them, because you need the mediators to create a culture of mediation. We have to bring them out. So that is a lot of work, but Barbados, I'm still saying, Francis, is a good place to experiment. You are a small population, easy to try. Let's do that on the grassroots level. Create the mediation circle. Let's try it in every school, whatever number of schools there are. Please, let's work on it. I'm telling you, you will see the benefits that people get, and you'll see those people. You will actually be happy sitting with those people, and you will see that they can handle more complex matters than you think they can.
Yeah. Okay. Well, I don't disagree with you. I can see where unfortunately the obstacles are, but those are things that we can talk about, and but we have to be aware of them, because some persons can be very destructive and discourage others from doing good things, and especially if they feel in some way threatened by what those individuals are doing or capable of doing. So we have to be aware of the obstacles and continue to speak to those obstacles in terms of whether they themselves can learn how to be part of the more positive approach to mediation. We'll see.
Yeah, because I think we are fighting a lot of vested interests, because, like I said, in a community, if you can create that mediation circle where people actually can collaborate and actually not just resolve disputes, but actually be able to discuss issues on a fair, objective way, I think it's a threat to a lot of institutions, lot of institutions,
Yeah.
and the activists and the advocacy groups and the politicians. You are a threat to all of them.
There's the money side of it.
Yes.
Where somebody's going to say, well, in order for us to do that, we need a place, we need a room, we need a office, need a telephone, and where are we going to get the money from? And of course, there are a lot of agencies around the place that are willing to provide the funding for these things, but then they're going to be the first to say, well, why don't you approach the government to see if we can put some legislation in place? And the government is going to go to those places where you get these models and
And
use those models to
exactly.
draft legislation. So this is what's going to happen.
That's
As
why it
long
has
as
to.
we start to talk about money, this is what.
That's why the whole structure has to be created where you are not creating a structure. When it is under the tree, I there was a particular, I mean, one session I had in that World Mediators Conference, which was bringing people under the tree. Why are we talking about a mediation room and mediation table? Why this formal structure? Bring people under the tree. They can sit anywhere and do it. You don't need to create infrastructure. Like you said, if you want to create infrastructure, you will want the government to come in. And if the government wants to come in, legislate, control. So let it be a people's process. Let them do it where they want.
Some
No,
communities are being spoiled, in the
Hmm.
sense of spoiled, quote unquote. They expect now to have a room. They expect to have an office. In some cases, air conditioned with telephone, etc. Computers, etc. Fully internet connected, etc., etc. So we have these realities.
But Francis, I've taken a lot of your time. I know.
That's
I'm
okay.
sure there's lots to discuss, and it's always a pleasure discussing with you because, like I said, you have that mindset to actually look at it objectively. You're part of a certain system, but you can at least look at it in an objective manner, which is what the important part is. I think we need to do that. And 19th, we have that workshop, which we're just trying to look at if there should be. Well, actually, where my background on this symposium is that if I have to do this grassroots activity and identify those people with the mediator mindset, first of all, legislation should not come in the way to create that culture, that circle in places. So I'm just looking at the other thing is I'm putting together a global pool of mediators because it's not that you can find lots of people with that mediator mindset. So you won't have very large numbers available. So the resources available in each part of the world should be available to people in the other part of the world because that's what the whole concept is. And with the online world, so legislation should not come in the way for that also. So global, you can go to whoever in the world you want. Why should you be anyone tell you that you can't sit with so on and so? So that part of it, for me, that's where legislation comes in the way, that control whom you can sit with. So that when a global pool is there, you should go to anyone. The other part is wherever in the world you do it, location cannot make a difference. If I want to say I'm on a holiday and we go for a holiday sitting on a beach somewhere and we are mediating and settling it, how does it matter? Place doesn't matter. So place should go out of the picture. Finally, that wherever you do that settlement, it should be enforceable wherever that subject matter is, and it might be in various places. So that's the way I look at legislation, that it has to take care of what I understand mediation to be and how the process should go and what it is. It is a people's process, their trust of the person, their trust in the process, and the outcome that comes from that is their outcome. It should be respected as their outcome, and wherever it goes, it should be respected wherever. So that's the kind of thing that we look at. So 19th, let's discuss model legislation if we have to. So thank you very much. And of course, Barbados mediation circle. That has to happen.
Okay.
See you. Thank you, Francis. I've taken a lot of your time. Bye.
All right.
Bye.
Have a good evening.